Okay, thank you. Thank you everyone for joining us today for the NABC COVID-19 Industry Resource Webinar. Here at NABC, we recognize the world has changed for our country, our communities, and our industry due to this global pandemic. The real-time challenges over the last days has put a lot of stress on our nation's food supply and our supply chain network. So we really appreciate all of you who have joined us this morning. It was actually a remarkable response to the invitation to join this morning and afternoon for a webinar such as this. We've continued to monitor the spread of COVID-19 and have been working with our members, industry stakeholders at a state, national, and international level to try to address the issues and provide resources and share that information to help keep blueberries moving during this time. Understandably, we've been fielding some of the same questions from our members regarding how to navigate this business environment we're in. Therefore, it was determined quickly by NABC leadership that we could quickly serve the industry by pulling together industry subject matter experts and in those areas that are most pressing to our members. It was also determined by leadership that the resources and information and access to these experts would not be limited to just our NABC members. So if you're a non-member joining us today, I would want to welcome you on behalf of our leadership, our board of directors, and our chair, Ken Patterson. We hope today's webinar is of value to you and your business. So with that, we've got a little bit of some of the logistics that will be involved with asking questions. We know that part of today's experience is going to be really enabling you to ask our two panelists today questions that they could answer from their expertise. So I'm going to turn this over to Teddy, and she's going to talk a little bit about how you're going to engage with our panelist discussion.
All right, thank you everybody. So you will see on your taskbar on the side that there is a tab called questions. If you have any questions throughout the webinar, go ahead and type your questions in there. Don't forget to press send. We'll get to them throughout the webinar and we'll finish all the rest of the questions at the end.
Okay, great. Thanks, Teddy. So our guest speakers today, Craig Regelberg and Ann Grotveit, are with us. I want to start by introducing Craig. Craig is the Senior Vice President at American Hort. He serves as the National Co-Chair for the Ag Immigration Reform Coalition, of which NABC has been a longstanding member. Craig is also a subject matter expert on H-2A program and policies surrounding agriculture labor. I've had the pleasure of working with Craig for many years in my capacity here and in the past, and we're fortunate to have him with us. We look forward to having him share about how COVID-19 is impacting agriculture's ability to access labor today. Also with us is Ann. Ann is attorney with Consors & Conway, a firm here in Sacramento, California, where clients span individuals, families, businesses, and numerous private associations, international and publicly traded corporations, state commissions, trade associations, chemical manufacturers, city government, special districts, and medical practitioners, land developers, and construction contractors. Consors & Conway has been an NABC attorney for many years, and I've had the pleasure of working with Ann over 10 years in my current and previous positions, and she's highly respected and regarded for her work and opinion in the area of employment law, and will be providing us with a brief overview of the Federal Family's First Coronavirus Response Act and discuss employer requirements and field some of the frequently asked questions that we've received from our members. So with that introductions, I want to turn it over to Craig, who is, we're really appreciative of your time here today, Craig, on a Friday in light of circumstances. So I turn it over to Craig. Go ahead.
Happy to do so. Thanks, Casey, and good afternoon Eastern time and Central, and good morning to the rest of you. Glad to be part of this today. We're going to be transferring over to showing some slides, so that's a cue to the organizers to get the slide deck up. And if there's something I need to do to facilitate that, just give me a little guidance. But let me just say, in the meantime, we obviously all are living through extraordinary times, very challenging and very uncertain times, and it's at the same time a little fascinating to watch spring unfold around us as if nothing unusual were going on. I grow some blueberries myself, not enough to be competition to any of you on the line, but they're in full bloom and they're being actively pollinated at the moment. And I know if you're to my south, you're further along, and if you're to my north, you're not far behind. And so I think that it's just important to recognize that our industry activities go on. We are collectively critical infrastructure as defined by the federal government. Our workers are essential workers, and we have an enormous job to do, frankly, putting food and agricultural products into the homes and on the tables of Americans. So it's in that context that everybody's figuring out how do we deal with the new reality while sustaining the rest of the reality that we're being looked to sustain. So with that, really my piece on this program is brief. I think that Ann has the heavier lift, so I'm just going to run through some top lines, and then we will hold questions and answers until the very end, covering both topics. I'll be talking today about the labor interface and particularly H2A, although not limited to H2A. I think my understanding of your piece of the specialty crop industry is that there has been a real spike upward in the employment of workers who are here on H2A visas, but there are also a significant number of domestic farm workers, whether their documents are every bit as good as they look or in reality not quite as good as they look. And so, many of the messages that I'll be sounding are really relevant in both contexts. Three things I want to cover. I want to talk about the status of visa processing, what's going on, and will workers that need to get here but are not yet here come, and what other changes do we see? And then ultimately, some considerations for employers. I have to tell you that I am not an attorney, so I will not be dispensing legal advice, but we know a bunch of attorneys and we have access to a lot of their resources, and so I'll be channeling some of what I've been hearing. Okay, so on the status of visa processing, I think that I already stated farm workers are considered under the federal guidance essential workers. I have not heard myself of any state that is questioning the food and agriculture sector as critical infrastructure, and by extension, our workforce as essential workers. With respect to visa processing, I think it's important to bear in mind that there are some country-specific circumstances that may cause for deviations from kind of what I'm going to say broadly. For example, at the U.S. Embassy in Jamaica, there was a COVID-19 positive case, which resulted in embassy staff being in self-quarantine for 14 days. It shut down visa processing. So we're in a pause period with respect to the processing of Jamaican workers. They're particularly critical up in the northeastern United States. There's an effort to get the embassy reopened. There's a congressional letter that Senator Patrick Leahy from Vermont spearheaded. But again, that's a very specific case, which really needs to be thought about differently than the broader narrative. Similarly, individual sending countries may restrict commercial activities or travel. In the case of Guatemala, they've put a hold on all incoming and outgoing flights. Practically speaking, that means if you're waiting for Guatemalan workers and they can't travel, you will see delays. So there are these exceptions. But I'm going to talk mostly about Mexico because, fundamentally, Mexico is the single largest sending region for temporary non-immigrant farm workers coming to the United States on H-2A visas. 70% or perhaps even more of that total workforce comes from Mexico, and Mexico is critical. It's mostly a good news story today, and in fact, some late breaking news that's not even reflected in my slides. With respect to Mission Mexico, the good news is consulates are processing H-2s, both H-2A, agricultural, and H-2B, seasonal, non-agricultural, many of which are important in the food system around agricultural production, seafood and some processing functions and whatnot. The consulates are again processing. Up until last evening, the stated priority was on workers that are eligible for interview waivers. This was partly reflective of the fact that the consulates need to rework their processes to maintain social distance and the safety of the consulate workers. And so for returning workers that are otherwise eligible to have their face-to-face interviews waived, that was the stated priority. That's a kind of good news story because the majority of workers are coming in qualifying for those interview waivers, but it's not all of them. And if you're a new employer coming at H-2A for the first time, you probably have newly recruited workers who would not have been eligible for those waivers. So we were very concerned about workers that may fall through the cracks and leave people in limbo. I'm going to talk in just a moment about what has happened as of yesterday, which dramatically improves our situation with respect to Mexican consular processing. But let me also first mention that we have implemented a partial travel ban at our southern border as of, I believe, Tuesday of this week. However, there are essential travel exemptions from that generalized travel ban. They include H-2 workers, they include cross-border trucking, commerce, and so from a workflow standpoint for people that are coming across the land border, we do not expect disruptions at this time. So on my next slide, you'll see there's a little bit of discussion about changes coming. And for continuity, I'm going to go to the third bullet first. These are the changes that came last night. And an hour after I hit the send button on the slide deck, that's usually the way life works. So as of last night, the State Department announced and USDA widely disseminated that they have made substantial changes with respect to interview waivers and are going to grant interview waivers in the consular process more broadly than they had prior said. So broadly, in fact, that we expect that virtually all of the workers that we might need up here in agriculture in the U.S. will be processed through the consulates under these new procedures. So this is good news, very good news that we're not likely to see folks falling through the cracks. Bear in mind that the consular official always has the discretion to require further information or frankly to deny visa issuance. And so there may be occasional exceptions, but the broad rule is the State Department will be doing H-2 processing of virtually everybody that's coming in under the H-2 classifications A and B. So for the other bullets on the slide, just broad backdrop, please remember we are expecting that the Trump administration may publish a final rule on H-2A modernization. There was a proposed rule published last July. The comment period ended in late September. There was some good in the proposal. There were some areas needing substantial improvement. That's not the purpose for today, so I'm not going to drill down into it. But just, we still do expect that there's a good possibility that sort of more generally new H-2A rules may come out sometime between now and, say, June. Secondly, in the current crisis, there is a robust interagency dialogue going on involving the Departments of Agriculture, Labor, Homeland Security, and to some degree state. And that has resulted in these State Department changes. We are also expecting that there may be Homeland Security changes that make it easier to facilitate the stay of workers already here, allowing them to transfer into other needs within the agricultural sector for other employers who have a temporary labor certification from the Labor Department, but that meant that the current somewhat cumbersome transfer process may be substantially simplified to encourage workers to stay, bearing in mind that some of these workers may not even be able to go home. Travel restrictions may impede their exiting, and it would be very unfortunate if a worker were considered to be out of visa status because they finished their job here, but they couldn't get home. So with that recognition, we expect some rule changes imminently that will inject good flexibility into that piece of the puzzle. So to wrap up, because as I say, I think Ann has the more complicated piece today, I want to go to my final, I think, slide, which will talk about some considerations. I think first and foremost, and regardless of whether you're talking about H-2A workers or whether you're talking about domestic farm workers, safety and the well-being of our workforce absolutely must be our top priority. It is essential. We defer to the health and safety related guidance that is coming from the relevant federal authorities. In the COVID crisis specifically, much of that is coming from the Centers for Disease Control. There is a short link on this slide that you can use to get to CDC resources. In a broader context, agriculture operates under various OSHA workplace safety standards. Field sanitation standard is absolutely relevant in this context. Many employers are going beyond what the basic OSHA standards require as relates to sanitation, hand washing, and so forth. But the legal requirements are spelled out in the relevant guidance. Is there going to be a change in your expected labor need, either up or down? And there are tools and strategies to try to adjust accordingly. I think if we do see these flexibility changes from USCIS to allow for workers to be more easily transferred, and changes already at DOL to expedite emergency petitions, I think we're in a better place with respect to the unexpected than we would have been even a week or two ago. In my own industry, where people are growing many times ornamental plant material destined for landscapes, the demand equation is changing very fast, and employers are seeing labor need plummet, or they're having to implement social distancing and other process reforms in the workplace that change how many workers they can really accommodate, and so they're having to work around that. What about workers that can't go home? I've really already kind of covered that the ideal situation is that they are not considered out of status, and that hopefully they can be effectively redeployed into other employment opportunities. That's a work in progress. A couple of comments, and I expect maybe there will be more questions on this, but a couple of comments about H-2A housing and quarantine. Obviously, housing is a real tricky point. Farm worker housing is obviously a critical resource. It is a very scarce resource. There's not a lot of excess capacity in many areas of the country. There are severe housing shortages, but you need to be thinking through your strategies of how will you respond at the business level if you have a COVID positive individual in your housing that has to be removed from that housing immediately and put into some other circumstances and put into essentially quarantine, and the housing has to be disinfected, sanitized, and maintained in a safe condition. So folks are going to have to think about that. I know of individual growers who have managed to leave a house or a discrete facility unoccupied and to manage it as a quarantine facility if, heaven forbid, the worst happens. Everybody's situation is going to be different, but you need to be thinking about how will you protect your workers. A lot of folks are asking about medical screening. I know there are some questions. I just want to say this is an area in which you need to proceed with extreme caution. The legal advice is not all of one mind about how we do medical screening. I've got a couple of things that I'm going to hold off because they respond to questions that have been submitted. But I think that there are more passive or more active ways to potentially approach the medical screening. And we have legal Q&A type resources that I would prefer that the lawyers raise the concerns that they would have over privacy laws, equal treatment versus disparate treatment, and some of the ways you might come around this. This is really Ann's wheelhouse, but I want to underscore that with respect to the new Families First Coronavirus Response Act, which has the sick and emergency leave mandates that Ann will describe, it is important for you to know that H-2A workers are not treated any differently for the purposes of this law than other U.S. workers, and the law applies to them. Again, Ann can go into the detail on that. I do want to point out that the context in which many H-2A workers are here is really different. You know, some of the emergency leave is around childcare, school closures, you know, spousal care, and the context for H-2A workers, they're not going to tend to have spouses or children here in most circumstances. So the sick leave may be more applicable than the emergency leave, but ultimately the law does not treat them any differently, and it's important to know that. I imagine there's a few other things that we'll go into when we get into Q&A, but again, very pleased to be with you all today. And kudos to Casey for finding somebody with an impossible Dutch last name and with an impossible Belgian last name to speak to you today. With that, let's transition to Ann.
All right, thank you, Craig. And I think we're ready. We're pulling up your slide now, so appreciate that, Craig. And we're ready to go when you are.
That's okay. Hi, everyone. Thanks for attending. I'm going to start off. I have a bit of different information in slides, and I can tell from the questions that we're probably going to get into a few different areas. I'll start first with the Federal Families First Coronavirus Response Act and just go over the overview right now. If you want to go to the next slide. So we have employer requirements, and I'm going to address one of the first questions right away. Is this applies to all employees? This is if you are under the guidance of having 500 or less employees, then it would apply to all of your employees. There is no restriction for seasonal workers, and there's no requirement that they have a certain number of hours or days worked. There is a cap. It's up to 2 weeks or 80 hours of paid sick leave. It is at the regular rate of pay, unless they are unable to work because they are quarantined or taking care of another person, in which case it would be at 2/3 of the employee's regular rate. That's the second bullet point there. The quarantine would be subject to federal, state, or local government under the advice of a healthcare provider if they are showing symptoms, or importantly for care of a child. That would be because the school or the child care provider is closed or they are experiencing a substantially similar condition. If we could go to the next slide. So with respect to the paid expanded family and medical leave, that is for employees that have been employed for at least 30 days, which would be March 2nd under the terms of the Act. So in that situation, they are entitled up to an additional 10 weeks of paid expanded family and medical leave at 2/3 of their regular rate of pay. This applies only to the need for leave to care for a child. That's one question I've been getting a lot is, does this additional 10 weeks apply if you are experiencing COVID-19 symptoms? No, the Act only provides for that 80 hours of paid leave for the COVID-19 symptoms. If similarly, another question that I've had, can they then take an additional paid leave for if they're sick with some other reason? No, you do not get an additional paid leave under this Act other than what you may already either be required to provide under state law. For example, in California, we have a 3-day paid leave, or in a different state, or what you may provide as an employer yourself. Now, this is the key thing where there are a lot of different questions. Paid sick leave and the expanded family and medical leave apply to certain public employers, but for our purposes, private employers with fewer than 500 employees. Small businesses with fewer than 50 employees may qualify for an exemption from the requirement if they can demonstrate that it would jeopardize the viability of their business as a going concern. Problem with that is we're going to need regulations to determine what that is, what jeopardizing the viability of a business as a going concern, and even doing regulations under an emergency process will take some time. So if you have fewer than 50 employees and you think you qualify under that, I would seek legal guidance for how you would document that it would jeopardize the viability of your business as a going concern going forward. It does not apply to large employers of 500 employees or more. Next slide. So, qualifying reasons for leave. An employee qualifies for paid sick time if they're unable to work or due to a need to leave because the employee is, number one, subject to a federal, state, or local quarantine order related to COVID-19. So the first item for, I believe, most of the people who are participating today is probably not going to be an issue because most of your employees are likely to be essential employees due to the need of agriculture. So we're not going to worry about number one very much. Number two, if you've been advised by a healthcare provider to self-quarantine, which would likely be because you have been in contact or a caregiver for either yourself has COVID-19 or you are a caregiver for someone who has COVID-19. If you yourself are experiencing these symptoms and are seeking a medical diagnosis, Or number 4, again, caring for an individual who is subject to the quarantine or seeking a medical diagnosis. And finally, if caring for a child whose school or place of care is closed. And then we have a catch-all, experiencing any other substantially similar condition specified by the Secretary of Health and Human Services. Again, we haven't seen those specifications yet, but that hasn't been much of an issue yet. Next slide. Okay, so the duration of the leave. There is a cap on this. It's up to 80 hours of leave. It's the number of hours of leave that they work on average if they are part-time. That would be based on a 2-week period, and some of the guidance I have seen is that you would calculate this over a 6-month period if it's an inconsistent hourly rate. For example, they work 20 hours 1 week, 30 hours the other, you would average it over a 6-month period. With respect to the child care, it's up to 12 weeks of leave for 40 hours a week. If it's part-time, it would be the number of hours, again, that the employee is normally scheduled to work over that period of time. Next slide. So calculation of pay. There are caps on this. It's either the regular rate of pay or the applicable minimum wage, whichever is higher. It has got a maximum of $511 per day or $5,110 in the aggregate. Similarly, for childcare, it's at 2/3 of the regular rate or the applicable minimum wage with a cap of $200 or $2,000 in the aggregate. Similarly, for number 5, again, 2/3 the regular rate. However, that is going to be a larger amount because of the 10-week period or 12-week period if you would qualify for both, where you could have over a 12-week period with a cap of $12,000. Next slide. So tax credits, and I'm just going to touch on this because right now, as you're probably all aware, there's another act that's being discussed and voted on in the House today that may provide a little bit more information and more readily available relief on the tax credits, but basically covered employers will qualify for a dollar-for-dollar reimbursement through tax credits for qualifying wages. They are paid to the employee who takes leave under FFCRA for a qualifying reason. It could extend to amounts paid to incurred to maintain health insurance coverage as well. As you see, we have the catch-all on the bottom to check the Department of Treasury's website. We've seen some guidance that the CARES Act is going to allow the tax credit to be taken by withholding the amount of the eligible credit from the employer's payroll tax deposits. A couple of things that I'd point out here, not a tax expert. I believe that the questions about this in detail should be posed to your accountant or whoever handles your accounting. But I would also say, I think this is, as Craig pointed out, this is really a fluid situation. I don't think I've ever said that statement more often than I have this last week. And what I mean by that is, this is the guidance and what we know today. Candidly, things have changed dramatically over 24-hour periods several times over the last 2 weeks. So right now, this is the guidance that we can give you today. I fully anticipate that the Internal Revenue Service and the Department of Labor are going to be putting more information out on their websites in terms of how these tax credits are going to be handled. I think the folks who are going to be able to most easily digest that for you are going to be tax experts. And so in that situation, I think the first call, if you have questions about that, should be to your accountant. One other thing I'd point out about this, we got some guidance that came out again late yesterday, not unlike the H-2A issue. And that guidance says that there is going to be a minimal stay of enforcement. It's from the time of signing, it's a 30-day stay, which would take it from March 18th through April 17th, 2020. However, I think that's a strange time frame because it really doesn't take effect till April 2nd in terms of the timing of it. So I'm wondering if that may be extended. And the stay of enforcement actions for the FFCRA will apply to employers who are making a reasonable good faith effort to comply with the law. I think what that's going to imply is if there's not a technical violation when you've tried very, very hard to come into compliance and make sure you're doing what you're supposed to do, that will not be enforced. And then next slide, please. So I think I saw a few questions on this from Casey, but I suspect most of you have already done this. Certainly if you're in California, I suspect you have, because we've been under a stay-at-home shelter-in-place order for a while. But one of the things we did initially is distribute sample employee letters. Now this one is California specific. However, what it references, because our governor's executive order did follow the Department of Homeland Security critical infrastructure sector guidelines. This one has the beginning of that listed. I don't know what every other state is going to be doing, but I think that's probably as good a guidance as is out there, and it should be somewhat consistent across states when these shutdown orders do come into effect. So what we have been suggesting is that you tailor it to your industry. There is a section on agriculture, and we provide this, fill in the names, and you give that to your employees, particularly the ones who have to travel, so that in case they are pulled over by law enforcement, they have the letter. My guidance on this is if your sample letter should follow the guidance of your state. If it's not your state, I know here we had many local jurisdictions issuing shelter-in-place orders first. So again, your sample letter may change because you typically starts local, moves on to the state. So if the state guidance changes it a little bit, you might want to alter your letter. We haven't had many issues with that in California. The governor did specifically state that his interest in this was not to create a lot of enforcement issues. But I will tell you anecdotally, we have heard some stories of folks being pulled over early on in this process. I'm not sure if it's continuing to happen. But we do recommend that your drivers in particular carry this letter with them. And then finally, next slide. So I know some of the questions, some of these are similar websites that Craig had, and I apologize to the extent the ones on the bottom say Cal OSHA. Those are actually the federal OSHA websites. Wasn't my intention to be California specific on that. So those are the same websites, one of them at least, that I know Craig had, as well as the CDC website. The one on top, which is the EEOC pandemic preparedness, that was updated late last week. I do find that to be some good guidance on questions that you can ask, because there's been a lot of questions, I think, about screening. To me, screening is limited at this point to potentially taking a temperature and asking certain questions. And this guidance provides some really good actual questions that you should be asking people so that you do so in a way that will be ADA compliant. For example, taking temperature is something we typically do not want you to do because it would be considered a medical examination. However, in a severe influenza situation, or certainly a pandemic like we have now, the CDC guidance has actually allowed for that. One of the things that I do have to stress, and the EEOC guidance says this as well, is you can be COVID-19 positive and not have any symptoms at all. You can feel fine, is my understanding, as well as not have a temperature. So one of the things to keep in mind is even those employees who show up, don't have a fever, feel absolutely fine, it's still very, very important to be practicing social distancing. To be practicing the good hygiene that I know most of you have probably seen in many, many guidance sheets about washing hands and having different stations set up where folks can wash their hands and use wipes, things like that. But I do really recommend that top website at the EEOC. It does provide some good guidance, at least on the questions that you can ask and how you do want to be asking them. That's what I have in terms of presentation, but I suspect that there are lots of questions. So we can go ahead and throw it open, I think, Casey.
Yeah, thanks, Ann. Thank you so much. And I know we have some time constraints, therefore I'm gonna pivot right over to Craig. And I know, Craig, you've got some questions in front of you that that have come over. If you haven't had a chance, I think Teddy has the description of how to ask questions. So as we go through the Q&A here, I certainly want to welcome those of you who haven't had your questions asked yet, or if something came up in the dialogue that you heard already this morning, to just go ahead and use these instructions to ask further questions, and then we'll try to field those as we go. But with that, Craig, I know you've got a question from Mark in front of you, if you want to tackle that one first.
Yeah, there's actually two you submitted, and I'll take them in rapid succession if that works for you. I think, first of all, Mark asked whether there are any known cases in agriculture. I mean, I can tell you that I am not personally aware, but I suppose just given the complexity of the situation, it really is only a matter of time. And we and our workforce are all in this together. It is in our absolute shared interest that we do everything possible to prevent clusters of disease emerging that will result in workers' livelihoods potentially being somewhat interrupted, and production operations potentially being significantly impacted. So all that is to say, everything that the employer can and should do with respect to the health guidelines, with respect to distancing, with respect to rethinking processes, with respect to frequent, maybe even daily education, outreach, touching base with the workforce, making sure that they understand the fact picture and the precautions that they personally need to be taking, and what the business has done to facilitate that. That's just all really, really critical. And so no known cases that I have heard of yet. That doesn't mean, I mean, I'm not an authority that these things get reported to in the normal course of business. I might hear about them anecdotally, but I just think we all need to be extraordinarily cautious. Secondly, timing of changes, that the changes, I think I referred to two sets of changes, that one that took place yesterday, that's the State Department's modifications to their consular processing. And by the way, I misspoke a number, so I want to correct it. Mexico as a nation is responsible for over 88% of the H-2A workers that are coming to the United States. The Monterrey consulate specifically is responsible for processing roughly 70% of that portion. So I misused my 70% number. So Mexico is 88%, which is why we're so concerned about it. And Monterrey is the big dog in the consular process, but there are others that play an important role too. The question, there was a question asked about so the timing of changes. The State Department changes, we are told, take effect immediately. Now, is there a bit of a lag time in consular practice actually changing? Hopefully minimal lag time, but the changes were effective as announced, and they are temporary. They are intended to end at the very latest December 31st of this year. So this is kind of an emergency workaround to enable the consular processing of H-2s to happen as it needs to. Related to that timing question, it was about which areas of the country, and obviously the production seasons and berries vary based on the crop, and they vary south to north. And I'm not the last word on whose dates of need begin when, but I expect that there are some employers whose workers are coming directly to them and will need to enter as particularly as harvest ramps up. There are probably other workers that are already in country and are routinely transferred among employers, or are moving among employers who are availing themselves of the services of an H-2A labor contractor. If those folks are already here in country, obviously facilitating smooth transition from job to job is in our shared interest. Final thing, kind of in this bundle of questions, and then I'll take a pause. There was one submitted prior about whether individuals are screened prior to leaving. I am not aware that there is any medical screening that is done routinely in the consular vetting process, and I think the the interview waiver situation that we're moving into is probably makes that even less likely. Though it is not routinely done, it is also not routinely done at the land border crossings. The only medical screenings that are currently in place that are non-routine, as I understand, are people traveling from the European countries, US citizens and legal permanent residents coming back from Europe, who are going through screening processes at I believe it's 11 airports that are approved to be receiving them. But I think all this really means that these workers, upon arrival here, it's just critical that their orientation involve good information on COVID-19 prevention, good information on nobody should be coming to work sick. And then I'm going to defer to the resource that Ann pointed to on screening in the workplace and what can be done and what shouldn't be done and what needs to be done with care. I think it's better for me to defer to that resource on that question.
Okay, thanks, Craig. Ann, did you want to tackle that, or I've got a number of questions that are coming in now, so.
The only thing that I'd add, here in California, I don't have personal knowledge because in terms of a client contacting me about this, but it has been reported in the news media that yes, we have had agricultural cases. That is perhaps a good way to start off as to what happened in that case, as it was at least reported in the news media, is that person tested positive, was sent home. And any person that they had been working with, they were practicing social distancing, but of course you still, are around folks, was contacted and advised. The situation there is, of course, you want to advise people that they have come into contact with someone without identifying, and the EEOC guidance is very clear on that. You want to maintain confidentiality as much as you can, understanding that in a employment context, sometimes folks figure things out. So that was the situation there, and that person was sent home. It's very similar to what employers in all industries are doing across the nation right now. Certainly because it was an agricultural context, I think they were working in a situation where they were at least 6 feet apart. I don't think there was a need to do a widespread, send an entire group of folks home. But in theory, that could happen if it was an office environment or much smaller. I can answer another quick question that I got ahead of time about workers' comp. So I believe we have people on this meeting who are from all over the United States, and workers' comp is generally has different laws in each state. For example, in California, I believe we have a much broader interpretation of what would qualify as an injury or disease. So the question was, if someone we employ comes down with COVID-19, how do we know that they caught it at work? Well, you don't know. Again, in a state like California, they would bring a workers' comp claim and the insurance carrier may accept it or deny it, and it would follow through that process. And that's what I would recommend you have your employee do. I understand, at least in Georgia and I believe a few other states, there are statutes that specifically say if it's a disease of general exposure where you could easily get it from anywhere else, that it is not going to be covered. I would still let them bring their claim. The insurance carrier may deny it, and if they may feel the need, the employee may feel the need to go out and get an attorney and perhaps fight that, but that's their decision. It also may be, again, because it is a fluid situation, we may see governors tend to have extraordinary powers in an emergency situation to suspend or revise certain things or ask the legislature to look at an exception. So it might be that things change. As of right now, I think you still have them go through the same process you would normally and just let the process take its place.
Okay, and I've got another question here. I'll just read, and then I think it has to do with the 50+ employee, but under 500. Wanting to clarify understanding of the sick leave law. We are a pretty small farm in Florida, but during harvest, we do have perhaps 50 to 60 H-2A workers picking during the busiest days. Does the sick leave law apply to us if one or more of the pickers get sick and cannot work during the harvest time?
The law applies to you, I think, regardless of whether someone is sick or not. So I don't think that's the criteria. The criteria is the number of employees. And yes, if at the time you are over 50 and under 500, well, right now it's if you're under 500. There is no actual regulation. I have to caution you, while they have stated that they're going to be promulgating regulations that would provide some relief to folks who are at 50 or under. Number one, those regulations haven't been promulgated. Number two, we don't know what they're going to look like and what the requirements are going to be that you're going to have to demonstrate to say that it jeopardizes the viability of your business. Now, I've seen some things that I don't think it's going to be quite that hard to justify, candidly, given some of the things I've already seen happen in our economy with, the layoff notices and things like that. But we don't know what those are going to look like. So I think you should approach this for at least until April 17 from the standpoint that you are going to have to comply. And yes, with respect to the 80-hour sick leave, that would apply if somebody seeks leave because they have COVID-19 or are subject to the quarantine order, then you would have to do that. You do not have to provide the sick pay leave for any other reason that is not COVID-19 related. I hope that answers that.
Okay, all right. I think this next one could be for either of you, but I'll kick it over to Craig. It says here, the question is, if an employee uses the benefit of their Social Security number, it turns out to not be valid, will the employer still be eligible for the tax credit?
Ann may have some thoughts on this too. I'm not a lawyer, so I'm not going to give legal advice, but I will tell you that in frequently asked question guidance that we are developing right now, I think the proper way to view this is if the employer has completed the I-9 form and has been presented with documents that are acceptable for establishing identity and authorization to work in the United States on the I-9 form, we are not anticipating that there is going to be sort of an e-verify check or anything like that in this system. We do not believe that there is any reason to be particularly worried if a worker, based on how the tax credit piece of this thing works, it's sort of at the employer level rather than at this specific employee level, is my understanding. Ann, do you want to add to that?
I would agree with you. I was going to say the same thing. If you have followed the normal procedure with respect to the I-9 and obtaining identification, I think that that's the most that they can ask at this point. I would anticipate we should see in the coming days some more information on that, but for now, I think that's good guidance.
So, and this is, I don't know that this is necessarily the lane of today's conversation, but there is a common theme of questions about how to maintain social distancing in light of workplace conditions. So whether it's a packing shed or I think even we have a question here about how do you do interviews or how do you hand off payroll. So there's just housing. Housing's another one. How many people are living in a similar space and keeping that social distancing in mind. So maybe you both could just quickly tackle what you believe to be best practices in that area, or at least the things that you're hearing other employers and industry sectors having to deal with in this area.
I can start with the housing, and it's going to start with your local jurisdiction. So even before we had this situation, I know the issue of H-2A housing should follow the zoning and the ordinances of the local jurisdiction wherever that housing is located. And that should include requirements for how many people to a room, how many people to a building, depending upon what the type of building is and what type of area it is zoned for. So that should be addressed no matter what, regardless of COVID-19. You should be in compliance with those local laws for your H-2A workers. Where we get into an area that we're in a brand new world is, I understand that many of these are dorm style housing is what I would call them. Again, the number of folks in that dorm style housing should be what is allowed under your local jurisdiction ordinance. If someone in that situation becomes sick, the best guidance that we can give right now is, yes, that person needs to be removed and quarantined. Now, if you're anything like California, that poses a significant logistical hurdle because we just don't have a lot of space. I know here and the other side of my office are lobbyists, and I posed the question. Our governor has exercised a lot of authority to commandeer hotel space for various things, as to whether we need to, as a group, push for some sort of accommodation from a public health standpoint. I also think that our local public health and our state public health officials should be providing more guidance on this if you have the need, meaning that if it becomes such a situation of lacking the ability to house a good spacing, the number of people who may test positive, but may not be sick enough where they have to go to a hospital. How do you address that? So I have escalated it on our end to try and put some pressure on officials to provide that guidance or provide options for folks, because again, here in California, I know we have very limited ability to obtain any more housing at this point. I suspect there are other parts of the country that have the same issue. But in terms of what you should start off with, what you should be starting off with is whatever your local ordinance has allowed and provided. So that's that issue. I'll stop there before I talk about screening, the intake or social distancing issue, and see if Craig wants to add anything more.
Yeah, I mean, I would just say that we're getting a lot of questions where people, want the comfort of knowing that the special agricultural treatment as critical infrastructure and as essential workers somehow grants them a quote exemption from things like social distancing. My understanding of the legal framework of the CDC guidance is that it is guidance. But I have also heard, and Ann may want to comment on this in a moment, that enforcement, which may come at a more local level, may be looking, state orders and potentially local orders and enforcement may be taking guidance and making it, in essence, the law. I'll let Ann comment on whether she sees that and so forth. But I think more broadly in production, I just sort of have to say we feel your pain in terms of it is not necessarily easy in highly labor intensive aspects of agriculture to figure out how to rework processes, especially where there might be machinery or mechanized lines involved that have specific tasks that take place at very specific distances. It's very difficult. Can lines be slowed down and staffed differently? Can certain processes, are there workarounds? I mean, I just think it's so business specific that people have to get very, very creative on their own business level about what they are able to do. I think one positive thing in the production ag context is that I think we are well insulated from the sort of closure threats that there are other aspects of even my industry that are sort of operating in gray area with respect to the strength of their arguments about whether they are or are not critical infrastructure and their workers essential workers. And I think if we see disease clusters popping up on landscape crews, for example, it's going to be a much more difficult conversation. I mean, at least in the agricultural context, everybody knows that agricultural production and stable food supply are fundamental goals, but that doesn't alleviate the responsibility on the employer to do everything imaginable to make sure that the workforce is educated and is able to comport itself in the safest possible manner.
Well, it looks like the questions are coming. I've been kind of asking questions at groups, what I'm seeing come through here, but One of the questions that was asked is about the movement of labor across state lines, and I think, Ann, remind me, because I've seen a number of these letters, but was your letter the federal version of that letter?
It was. It's a California-centric letter in that it references Governor Newsom's executive order and the shutdown, but it does the criteria that we put in it was the Department of Homeland Security critical infrastructure language.
Yeah, and I think that is the answer to the question that I've got here about ability to move employees from state to state, recognizing that the essential employee relationship would carry wherever they're going. But this was a question about moving employees from Oregon to California. So I don't know if you guys want to tackle that, but I think that's been asked and answered.
Yeah, and I think the one positive thing in this corner of the universe is I have not seen any state that has questioned or deviated from the federal guidance with respect to the food and agriculture sector as critical infrastructure and farm workers as essential workers. So, I mean, even though the federal language is guidance and the directives and orders are state or sub-state, nobody is that I'm aware of is deviating from that, which should alleviate the risk.
Agreed. And I think
Okay.
there's been some specific guidance for the long haul truckers as well.
All right. I think that's going to be it for the questions. So I think we'll wrap it up. I just double checking that I didn't miss one over here. But with that, I really do want to.
Casey, can I jump in on you? I'm sorry.
Yeah.
There is something I wanted to mention, and I'm not sure that I really. Actually, I may have touched on it, but the questions are coming in faster and faster about visitations of housing by people that are not housed there. And I think I did make reference to the fact that there may be privacy and freedom of association considerations that bear down on how workers' lives are controlled 24/7. But I think that there is a really important opportunity for education in this space so that workers understand that that minimizing social contact outside of the immediate groups, that, for example, if they're housed on farm or in farm arranged housing, minimizing social contact and adhering to the health guidelines themselves in any social contact are really, really important, because if if visiting friends or relatives, somebody comes into a facility COVID positive, it's a cascading downward from there. And so I think that individuals need to act wisely, and educating the workers on how to protect themselves and their peers in the workforce, I think is a really important thing for employers to do.
Yeah, and I'll throw it just out there if there's anything else, Ann, that you might want to add, knowing that I think that was it. I was just double checking questions. We're good. And do you have anything else you'd like to share?
With the question on screening and setting up payroll and things. So it was an interesting question because, of course, here in California, we want everybody to be using electronic payroll because we have specific legislation that makes anything other than that very difficult. So to the extent that you are still operating in a different way, this isn't really legal advice. It's really more checking the guidance. But I mean, you want to practice safe practices of, to the extent that you have to change the logistics of your setup temporarily, of wearing gloves, using drop boxes, things like that, encouraging people when they pick things up to then wash their hands later, things like that. That's about all we can suggest at this point without any additional guidance from the CDC of anything else. Is have hand soap available and wear gloves to the extent necessary. With respect to paperwork that you're concerned about touching, leave it in a drop box, put on some gloves, maybe put it in some sort of a bag type situation for a while. The guidance I've heard is, yes, this virus will live on certain surfaces for a few hours. I'm not sure that paper is one of them. That's a very big risk, but you know, take those precautions. And most important, don't panic if you touch something, just go wash your hands is what I've heard. Again, that's not legal guidance. That's just what I've been hearing on the news. That would be my general guidance about trying to just set up a logistical situation where you can reduce the touching on hand-to-hand distribution of things as much as possible.
Okay, all right. Well, with that, I want to thank both you and Craig and for joining us today. It really has been an invaluable opportunity just to get together, recognizing that, you know, we kind of turned this webinar around in about 48 hours, and we had a great turnout, and I really do appreciate the time you gave us on a Friday to just kind of ask you questions about these areas that we're getting a lot of questions about. So we really appreciate the time here with the both of you. Thank you very much. I also want to thank Teddy, our facilitator, for helping us put this webinar together so quickly, and my team at the NABC for the support all week to try and get all the communications out that have been going out daily this week and last week, helping us be able to reach as many of you as we have. So I would just, again, point to some of the resources that we have been making available from the NABC. As a reminder that we have our COVID-19 resource page. You'll see here on the screen, the NABC Blues. Actually, before we move on, we did have that slide. Can you go back one slide to Craig and email addresses? Typically, you know, in a setting like we had in DC where you could, you know, talk to folks after, I do want to encourage you to feel free to reach out to both of them. Their emails here as being a value add to the continuation of this conversation. But at a minimum, I would just say, click on their email, type them a thank you for the time we've had with them today. I think it would mean a lot to them as well. Again, going to the next page, just the resources that we have. We have the nabcblues.org, where you can see there's a little red bar at the top of the landing page now where you can click, and you can see we've got two areas. You can keep up with the newsletters that we've been sending out daily, as well as the resource page as well. We encourage you to share that broadly. Again, these are both member and at this time non-member benefits in order to get as many of these great resources into the hands of people in our industry as possible. And again, an email from today's webinar will follow. We're going to do our best to continue to answer the questions that you have. And if we didn't get to a question that came in after we cut the questions and answers off, we'll get back to it and we'll try to answer those questions working with Craig and Ann. Again, thank you for joining us today. We trust that this has been of value to you. Please be on the lookout for more efforts from NABC and USHBC to help our industry continue through the challenges of the day. We'll, at this time, conclude the webinar, and thank you for joining us, and have a great weekend.